Solicitor General of India, Tushar Mehta, today appeared and argued on behalf of the central government in the case of Facebook India head Ajit Mohan versus Delhi's Peace and Harmony Committee. Solicitor General Tushar Mehta first of all clarified that he is neither supporting senior advocate Harish Salve appearing for Facebook India head, neither he was supporting senior advocate Dr. Abhishek Manu Singhvi appearing for the Delhi Assembly. He primarily argued that if a subject matter is specifically mentioned under List 1 of the Constitution and the same matter is mentioned generally in List 2 of the Constitution, then the mentioning under List 1 or the Union List will take precedence over the mentioning over the state or the concurrent list. Solicitor General of India said, "There is a Parliamentary Standing Committee on Information Technology looking into this. I'm not supporting Facebook or Twitter. It's a global, uncontrollable problem. We cannot have 28 assemblies decide what to do and what not to do. If there is a problem with Facebook, then answer is not giving power to state assembly to summon them. It only needs a national response from the parliament, and it cannot have 28 assemblies taking a call on this. I am giving an extreme example, but your lordship is laying down the law. Just imagine, if all the 28 assemblies contemplate issues regarding defense of the nation, can they summon witnesses for the purpose of discussion? This would be a colorable exercise of power." However, the bench of Justices Sanjay Kishan Kaul, Rishikesh Roy and Dinesh Maheshwari maintained that the primary question that the central government has to answer is the Delhi Assembly, without the three specified entries of law and order, police and land, can it summon such people to have a discussion in the Assembly? And if they are having a discussion over a particular subject and not necessarily exercising a legislative power, can it be said that they are breaching the subjects that are mentioned under the List 1 of the Constitution? Solicitor General Tushar Mehta has sought liberty to file a detailed affidavit in the court by Monday. This case would now be taken up on Wednesday for further hearing. A Chief Justice of India, S.A. Bobde-led bench today adjourned a batch of petitions challenging the Uttar Pradesh Ordinance and the state laws of Uttarakhand, Himachal Pradesh and Madhya Pradesh prohibiting religious conversions for the sake of marriage. The Chief Justice of India bench was informed that the councils has sought an adjournment in the case. Jamiat Ulema I Hind has sought to intervene in this particular case. Advocate Ejaz Maqbool, appearing for the Muslim rights body, presented before the Supreme Court a scenario where hundreds of Muslim youth across the country were being harassed due to these specific laws. To this, the CJI said that he would hear the intervention application filed by Jamiat Ulema I Hind. The court has also stated that now it would hear the fresh challenge also to the Himachal Pradesh and Madhya Pradesh laws prohibiting such religious conversions. A two-judge bench of the Supreme Court today, led by Justice Abdul Nazir, heard a plea by Franklin Templeton challenging the Karnataka High Court order restraining the winding up of its 6 debt schemes without obtaining the consent of its investors by a simple majority. Senior advocate Ravindra Srivastava, appearing for the investors, argued that SEBI cannot say that taking consent does not apply here. He further argued that consent does not necessarily mean that it has to be out of a statute book and that here consent was needed. SEBI must get in as a regulator, otherwise there is no other for the interest of the investors. The situation is not comparable with the shareholder of a company. Unit holders gave their money in trust. It is not a contract. Why should unit holders pay for some foul play? That is why it is due and payable. Somebody should look into it. What is being made is the investor's money. If we take that SEBI is just a silent spectator, that it does not have a role, if that is so, the purpose of the SEBI Act of protecting the interests of the unit holders is completely lost, said senior advocate Ravindra Srivastava. Well, after displaying that the case filed against journalist Rajdeep Sardesai was registered as a suo motu criminal contempt petition on Tuesday evening, by Tuesday night, Supreme Court sources informed Bharat Bench that it was a clerical error and that the status of the case as a suo motu case was inadvertently updated. As of now, the status continues to exist. However, the court sources mentioned that it was just an error by the registry of registering the petition filed seeking contempt proceedings against Sardesai as a suo motu contempt plea. It has to be remembered here that last year, Attorney General for India, K.K. Venugopal, had denied consent to initiate contempt proceedings against Sardesai. Well, that's all from the Supreme Court today. Do stay tuned with Supreme Court Today tomorrow as well. And don't forget to like and share BharatBench.com.